Good evening. Welcome to the Monday, September 17th, 2012 meeting of the Newmarket Zoning Board of Adjustment. I apologize for being late. And our first order of business is the Pledge of Allegiance. I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Next order of business is the review and approval of the minutes of the August 6, 2012 meeting.
I make a motion, we approve the minutes with Chris's edit notes.
I'll second it.
And further discussion? All those in favor, please signify by saying aye.
Aye.
I abstain. I was not present.
Okay, and nays? No nays? So it's 3-0, Mr. Rosa abstaining due to his absence. Our regular business agenda tonight is a motion for rehearing from Walter W. Cheney regarding a zoning board of adjustment decision on the following application. Walter W. Cheney, appeal from administrative decision. The applicant requests an appeal from administrative decision to allow for the issuance of a building permit, the application for which was denied due to the lot being determined as, quote, unbuildable open space, unquote. The lot is located off Cushing Road, tax map R2, lot 36-13, zone R1. This application was originally heard on May 18th, 2009, and a motion was made and unanimously passed to postpone any discussion on this issue until the lawsuits have been properly adjudicated and the board has legal answers in front of them by which the board can then render a decision, unquote. The applicant has requested a continuance of this meeting to be held, stating, quote, stating the, quote, resolution came on March 3rd, 2011, where the court ruled in the favor, I think in his favor, that Lot 13 was owned by Walter W. Cheney and that Lot 13 is an independent lot of record, unquote. This application was dismissed for lack of jurisdiction by a vote of the Zoning Board of Adjustment on August 6, 2012. Before we take up the merits of the application, Mr. Barr, who was present that night, is unavailable. He's working, I guess, extra long hours through the middle of October. Wayne Rosa was not present that evening, and I'm just going to inquire briefly. Have you had a chance to look at the... Let me finish my question. Have you had a chance to look at the video of that meeting? And have you reviewed all the documents that were submitted by the various parties?
Yes.
Okay, so you feel comfortable sitting in this application at this time? And I'm going to ask, is Mr. Cheney here?
No,
Are you speaking for Mr.?
I wasn't prepared. Sue called this morning and said there was a meeting. We didn't have notification that I'm aware of. I know he was definitely not aware of it because I would have heard. And he's out of town. I don't even have a way to contact him.
Okay. For folks at home who are wondering what's going on, I just inquired. Mr. Cheney is not present, and I'm was not informed of the date of tonight's hearing, and I am just looking to see what I can see from the record as to whether he was provided notice. It doesn't look like the town's attorney is here either. What is that?
Certified notes.
That's the notice of decision, right?
Yeah.
And I'm looking at the rehearing file. I did receive a letter from Mr. Cheney. I'm assuming everybody has seen a copy of it. You know, the formal request for a rehearing. But I don't see, so the record is clear, I'm looking, I don't see anything in the file on the rehearing. Formally letting me know that Mr. Cheney actually saw a copy of the agenda. I did get there's an email in the file dated September 11th from Trish Simon saying, having seen the agenda for the September 17 ZBA meeting, and there's obviously people here.
Who's Trish Simon?
I believe that she's my guess from the,
Okay, all right.
right, thank you. Did you not see this? It's not a,
I don't remember seeing that. Yeah, this is not addressed to us.
it's addressed to Sue, and it should have gone to
No names
everybody.
on one of these.
And my name's on it, and I apologize for that. It's in relation to the application. This creates a bit of a dilemma. So our options are to go ahead with the hearing and act on the application for rehearing, subject to Mr. Cheney coming in later and explaining that he didn't get notice, or continuing the hearing.
My understanding from reading the stuff is that we have the hearing and we don't, there's no formal notice procedure going out. We're just ruling on whether we're going to consider the application again. So there's no need for, we just have to post the agenda. We don't have to give notice to abutters or anything like that.
Oh, okay.
That's what I was told by Susan Morton as well, that abutters wouldn't be noticed unless there was a special reason the hearing was going to go forward, and that would be at another date, and we would be notified.
Yeah, it
That
does
was the
say
way,
that
that's the
down
way it
there.
was explained to me.
Sue says that here, it is a public meeting with minimum posting requirements of the right to know law, which is the posting of an agenda, but it is not a public hearing and no formal legal notice is given.
Okay. Having that in mind, it seems like the thing to do is to,
But it also says if Mr. Cheney can show that a technical error was made or he produces new evidence, the board may decide to grant a rehearing.
In the application I saw, there was nothing new presented. It was,
Well, no, but
that's,
you have a chance to present it?
Yeah, the point is, was there anything new between the notice of the decision versus right now that he's had a chance to bring forward? Is that what you mean?
Although she goes on and says if they do not grant the rehearing, they inform Mr. Cheney that the motion was denied. So it doesn't sound like, I don't know.
I don't know.
if there's no, so what you're suggesting, Bob, is that there's no requirement for formal notice under these circumstances. It's
Yep.
just a question of posting the agenda publicly.
correct, he gave us the request and gave the information in that, the points he wanted to make, but there was nothing new in there.
Okay, then I guess the thing to do, since we're all here, is to go ahead and have the hearing on the rehearing. Mr. Cheney has presented a 3.5 page document outlining the reasons why he thinks we should consider his application, or reconsider his application, I suppose. And hopefully you've all had a chance to review that. I know I have.
I have read it. I don't have them with me right now, but I have
Okay.
read it.
I read it also, and I didn't find any points in there that pointed to either an error on our part or a pertinent, or any zoning matter that we could act upon.
I guess I need to
Yeah, we're not
have,
only-
there's no one here to speak for the applicant. There's no one here to speak for the town. I guess I need to open a public hearing on this. Open, and
We're just
Or do we?
looking to take up whether we're gonna take any additional action on it.
okay,
I mean, there's no, I don't know, we can open up to public comment if we want, but I'm not sure what,
The lawyer already gave a ruling last time for the right?
I don't know if we're allowed to speak,
Are
but
we allowed to
we were
speak?
told
I'm
by your
talking.
office was
Don't
if there
speak,
was
yeah.
no technical change, then this was no technical change.
Okay.
And FX gave the ruling last on August 6th, so wouldn't that ruling still hold?
FX doesn't give a ruling.
Yeah, he didn't give a
Yeah,
ruling.
he doesn't, I understand what you're saying. We got some, we, I guess my inclination to err on the side of caution is to just allow public comment, limited to the rehearing, understanding the applicant isn't present. If it turns out that the public hearing was unnecessary, then so be it. So I am going to open up the hearing to public hearing for anybody who wants to comment. I'd appreciate it if, to the extent possible, the comments were limited specifically, well, not limited, but focus on the question of jurisdiction. Specifically, the reason we denied jurisdiction in the original hearing was that there's no provision of the zoning ordinance that seemed to be a basis of the code enforcement officer's decision. So the floor is open for public comment for anybody who wants to speak at this time. You're not required to, but you're welcome to. Don't feel like you have to, but if you want to, you're welcome to. And please state your name for the record.
Russ Simon, 510 Cushing Road. I think you were right on the decision you made the first time, and that your legal counsel said. I believe, is it Mr. Daigle? I'm sorry if I'm mispronouncing your name. But I've read the same thing. I'm not a lawyer, but it seemed that there were no new technical merits to rehear the decision that you did before.
Okay.
Thank you.
Thank you. Anyone else?
John Badger, Cushing Road. I think it speaks volumes that Mr. Cheney is not here tonight to pursue his application, and I believe it should be denied. Thank you.
Thank you. Anyone else?
Am I on drive? Do I have to get up?
Yes, yeah. So people at home can hear, and
Okay. I wasn't prepared, obviously, to come in and speak on his behalf.
just tell us who you are.
I'm Heather Brigham. I work for Walter Cheney.
Okay.
And I just want to say that in his defense, we definitely were not notified. I guarantee he would have canceled any plans to attend this meeting. I'm not sure if it can be rescheduled. I really don't know. I know, these guys aren't going to want to come back multiple times, and nor do I, or nor does he. So I'm not really sure the process, but I guarantee I can tell you he will object. So I at least need to speak on his behalf.
Okay, I appreciate that.
Sure.
Thank you. Anyone else? See no further comment. I'm going to close the public comment session and open it up for the board to discuss.
I have one question for Ms. Brigham. When is Walter scheduled back?
Next week.
Next week. Do we want to postpone, just give him an opportunity in terms of fairness, or?
I mean, you're saying that specific notice to him isn't required. I've got no reason to believe the agenda wasn't published in the appropriate places at the appropriate times.
Yeah.
I'm kind of inclined to say that maybe we should postpone as well, because we don't know for sure, but, if he's going to object, we're going to be back anyway.
Well, I don't know. I don't know if we're going to be back.
Right,
If
okay.
if he objects. I also,
Maybe
I'm
he will,
here.
maybe he won't, who knows? No.
The purpose we're here for is the statutes state that he's gonna come back for an appeal before he can go to Superior Court.
It's an appeal against our decision, and
Decision.
we look
So-
at whether there's anything.
So
Yeah.
if we reaffirm our decision, then he's 1 week closer to being able to get to Superior Court. If we put it off, I mean, I don't think it's gonna change my opinion.
I know, from that point of view as well, that's a good point, because we don't want to waste any more of his time.
yeah. My feeling is, unless you guys feel differently, is we go ahead, we act on this. If he comes in and demonstrates that he should have been given specific notice or something else that we may have overlooked, then we can take that up, and we're no
That's for
worse off than we
mulligan.
are now.
Right, okay, yep.
Is he entitled to another rehearing, or is there just
No.
one rehearing?
I think there's just one rehearing. I
I
think there's
see.
case law on that point that
Okay.
you, but if he can say that there's some procedural error, some
Right,
failure to
right.
comply with our rules of procedure, then we can take that up at the time. But we're here, we're prepared. Some folks clearly were aware and informed of the agenda of the meeting, so I think we should go ahead and consider the merits of the application and see what happens at that point, rather than guarantee that we're gonna come back.
Right, okay.
Okay.
Can I,
Not that I don't enjoy spending time with you guys, but
how were you informed?
We looked. We looked on, the agenda was posted in the town hall, and then I checked online to make sure it was the same one.
Okay.
And
We did not
checked
get
with
those.
the office saying, because last time we weren't notified when we should have been notified, because apparently Mr. Cheney provided our name, but in
No,
fictitious.
provides the name of the butters, and he didn't provide them all. And so I said, well, we weren't provided again with the butter's name, and that's when Sue wrote me the thing, as well as Diane, that there is no need to provide. But if the hearing, if you all decide to go back to looking at this motion, and there was a public hearing, then at that point, abutters were noticed. But I figured since he wrote and asked for the motion, that he would know that it was gonna be coming up at the meeting.
Or would at least be interested.
Yeah.
I think we have to be fair that he might be interested, but we're getting told that he didn't get the notice, so I'm gonna take that as.
We didn't get a notice either.
We
because
got
No,
I-
the notice, Jerry.
I
You
know,
know,
but
this is,
I'm just saying, that's all. It's just-
why don't we go ahead and...
I don't wanna talk about anybody when they're not
A
here.
motion?
Why don't we go ahead and, yeah, go ahead.
I'd like to make a motion that we reaffirm our decision of 8/6/12 and dismiss this for lack of jurisdiction.
So it's denying the motion to reconsider.
Correct.
Essentially a motion to deny the motion to reconsider.
Okay, make a motion, we deny the motion to reconsider.
Okay, I'll second that, and then we
Is there
can have discussion.
discussion? I think, Bob, you've already made the point that there's nothing new in here that relates to the issue of jurisdiction. It's a, it's a restatement of the merits of his
It's a
case.
summary of a much thicker document.
Yeah. Right.
Yeah, I think he's basically saying he wants to be heard, and he wants the town to do that first in his appeal.
Right.
But at the same time, if we don't have the jurisdiction, then there's not much point in
wasting his
it being
time.
us hearing it.
I've got 1,000 questions, but I guess I agree that we have no jurisdiction. This is not a special exception, variance, dimensional, so I don't, and he hasn't presented any of that in here, so I don't see where, but that doesn't
It'd make a
mean I understand
Make-
all of this
it'd
either.
make a fascinating
It's just-
2 hours.
This is a,
2 hours.
Mini-series.
2 hours for the open.
Mini-series.
my word.
We're talking about days.
Okay, well, let the judge sit. He
I'm
can
not
sit.
exaggerating. We're talking about days to piece this, but that's not a reason not to do it. The reason not to do it is that
We'd
is that
have
we
no
lack the
jurisdiction.
to do it.
Right.
Just because it's difficult doesn't mean we don't do it. It's just that we don't.
Yeah, I mean, that's what we based our decision on, and
Okay.
nothing's changed with that respect.
Okay, so is everyone satisfied
Yeah.
with our discussion? All those in favor, please signify by saying aye.
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 All those opposed? It's unanimous 4-0. Any further new or old business to come before the ZBA at this time?
Nope.
Seeing none, I'll entertain a motion to adjourn.
So moved.
Yeah, so moved, yeah.
Second.
All those in favor, please signify by saying aye.
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 All those opposed? The ayes have it, we're adjourned.